There are many articles available on the internet with titles such as How to Hire an Expert Witness. The ones that I've seen, which have been created by the American Bar Association, among others, typically provide attorneys with advice on the key steps involved in searching for an expert and conducting due diligence on an expert's background, experience, and suitability for the case involved. Based on my 15-year experience as an expert, a number of these key steps are sometimes overlooked by attorneys, or at least underweighted in the decision-making process. The best way I know of to learn about an expert is to very simply talk to attorneys that the expert has worked with. Not just any attorney that the expert has worked with, or even any attorney on the expert's list of references. In my opinion, the best sources of information are attorneys who have worked with the expert through deposition or trial. Lawyers who have done that would know exactly how the expert handles himself or herself through the heat of providing testimony. Also, they would know if opposing counsel was effective in discrediting the expert at deposition or trial, and why that happened. It isn't difficult to determine who should be the best source of due diligence information on a prospective expert. Many, if not most experienced experts, have on hand a summary of expert engagements that they've worked on, and they should be willing to share that information with a prospective retaining attorney. The expert's summary of engagements typically identifies the law firm that retained the expert in each case and states whether deposition or trial testimony was provided. By identifying the attorneys who have worked with the expert through deposition or trial, the expert's engagement summary also identifies attorneys who typically can provide the most meaningful due diligence information. An expert need not be formally retained before informally providing at least some preliminary opinions. I would encourage attorneys to share reasonable amounts of information about the case with a prospective expert, including the initial complaint and answer if they're available. The expert should then be able to provide at least some preliminary assessments of the strengths and weaknesses of claims of both parties, and preliminarily, whether or not the expert can support the retaining attorney's theory of the case. That informal discussion between attorney and prospective expert should speak volumes as to the expert's thought process and overall capabilities. Attorneys generally consider a well-reasoned, well-written report key to the successful outcome of litigation. With that in mind, attorneys should have the opportunity to review a writing sample from the prospective expert. The expert may be able to provide one or more completed expert reports if they're already in the public domain, or if they're no longer strictly confidential for various reasons. Or perhaps one of the expert's previous reports might be available in suitably redacted form. Alternatively, journal articles or other business reports may serve the same purpose. If the expert is not retained until late in discovery, the retaining attorney may miss gathering critical information in interrogatories and depositions, thereby weakening his or her case. Conversely, if the expert is retained at, say, the outset of discovery, with the expert's help, the attorney should be able to ask more incisive discovery questions in terms that are generally understood in the industry involved. There are many obvious benefits to this approach, not the least of which is reinforcing opposing counsel's sense that they are dealing with a most formidable